Hello, everyone, and welcome to our Lunch and Learn series. My name is Giselle Lopez, and I am the Executive Director of the New York State Youth Justice Institute. On behalf of the YJI, I'm happy to welcome each of you to this month's webinar. Thank you for joining us today in this virtual space and for making time to learn more about research into youth justice issues. If you feel like it, please feel free to introduce yourself in the chat. Our gratitude also goes to our partners in New York State, the Division of Criminal Justice Services, the Office of Children and Family Services, the University at Albany, and the New York State Juvenile Justice Advisory Group. Today, we announce the launch of a podcast episode produced by the YJI, which covers the school-to-prison pipeline and restorative justice. In this episode, the YJI team interviewed staff and leadership folks from Mediation Matters and from the Midwest Center for School Transformation. The resulting discussions focused on the COVID-19 pandemic and its impact on the school-to-prison pipeline, as well as restorative justice in schools. The episode is available now, and I believe somebody already put it in chat. So if you're looking for something to listen to while you commute to work or when you go for a walk, consider listening to our podcast. Thank you. But today it is our pleasure to host Victor Jones. Like all of you, I'm very much looking forward to his presentation. It is wonderful to have you, Victor. For a proper introduction, I will now pass the baton to Tawny Cruz. Tawny, the floor is yours. Thank you.
Thank you, Giza. Hello, everyone, and welcome to the Youth Justice Institute Lunch and Learn webinar series. My name is Tawny Cruz, and I am a research fellow here at the YJI. I'm super excited to be a part of today's webinar, and today we have the pleasure of hearing from Victor Jones. Victor Jones is an attorney at the NAACP Legal Defense and Educational Fund, where he litigates school desegregation and other educational equity cases. Prior to joining LDF, Victor served as general counsel and senior policy advisor for the Louisiana Board of Regents, where he developed statewide legislation and administrative policies to expand post-secondary education access for underserved populations. He was also senior supervising attorney for the Southern Poverty Law Center, where he, through litigation, public policy, and public education, led the Children's Rights Practice Group in fighting the school-to-prison pipeline, fighting for educational equity, and protecting children's access to mental health services in the Deep South. Before SPLC, Victor was a litigation and education associate at multidisciplinary law firms in New Orleans. So without further ado, I welcome Victor Jones.
Thank you for that introduction, and it is a pleasure to be here today. One thing that Ms. Cruz didn't mention in my introduction is that I also used to be a public school kindergarten teacher, and that is the impetus behind my journey into being a school-to-prison pipeline and educational equity lawyer. So throughout this presentation, much of what I will be speaking about will draw upon not just my experiences as an attorney, but also as a former public school teacher. So I'm really excited to get this started, and thank you so much to the Youth Justice Institute for having me. So I think it's best to do some table setting and to even just start with a discussion on what exclusionary discipline is. The definition that I will be working with comes from the Civil Rights Data Collection, the CRDC data set, provided by the U.S. Department of Education, which is a biannual survey that is sent to school districts that collects data on various aspects of enrollment, school climate, and school culture. Included in that data set is data on exclusionary discipline practices. And so what we mean by exclusionary discipline is what you see on the screen: in-school suspensions, out-of-school suspensions, expulsions, unilateral transfers to alternative education settings, school-based arrests, and referrals to law enforcement. And one thing that is also included in exclusionary discipline, but isn't talked about, is the practice of silent suspensions. I know in Louisiana, we conducted an investigation, I think maybe 3 years ago, and that was one of the reoccurring themes that came up. What we mean by silent suspensions is undocumented suspensions in which school districts or school teachers will send a note home to a parent or call a parent and say, your child is experiencing some behavior issues, so we're going to have them come home just to cool off for the day. That is a form of exclusionary discipline. It is classified as a out-of-school suspension. It is classified based on however many days the child is sent home. And those tend to fly under the radar. They tend to go underreported, but it is considered a form of exclusionary discipline. And so the first piece of guidance I would say to school districts, and I'll be providing plenty of guidance throughout this, is to even document those undocumented suspensions and expulsions, well, suspensions particularly. Biggest question is, do exclusionary discipline practices curb behavioral infractions? No. Decades of research has shown that exclusionary discipline practices are not only ineffective for changing student behavior, they lead to worse social, behavioral, and academic outcomes. And I've provided the link to that study that also cites to prior studies that confirm as much. There is no evidence that resorting to exclusionary discipline practices somehow changes or improves overall student behavior individually or collectively. And so that does beg the question, well, if they don't work, then why are they used in schools? And I think that's a really good question, and that's what we will be talking about at large today. So while the data says that there's no evidence that exclusionary discipline practices work to improve behavior, there is decades of data and research that shows that exclusionary discipline practices does yield adverse outcomes, not just for children, but for schools. And the points that I raise in this slide, if you need the research on them, you can reference my article, shameless plug, COVID-19 and the virtual school to prison pipeline, which I'll provide in the chat. It provides all of the research insights for these findings. And so the first outcome that I thought was interesting was reduced political and civic engagement, including voting and volunteering. Professor Aaron Kupchik, who is a school discipline expert, and provides a lot of school discipline expert testimony in lawsuits, did a study and found that the students who had been subjected routinely to suspensions, or the students who had been expelled once they reached voting age, that they were less likely to participate in voting compared to students who had not been subjected to those exclusionary discipline practices. The most obvious outcome is the engagement in risky behaviors, criminal conduct, drug use, and adolescent sexual intercourse. When I was working on my master's in education, my focus was in school counseling, and I worked with a group in Roxbury, Massachusetts, a group of students who were juvenile system involved. And one of the biggest themes from our conversations is that they all started engaging in sexual contact while they were on suspension and while the other person was on suspension, right? And so we're talking about teenagers who are unsupervised during the day, who have been sent home because they've been either suspended or expelled, and that leading to those students engaging in these risky behaviors that are outlined here. Poor educational outcomes. The data is very clear that when children are removed from the general education setting for significant periods of time, whether it be because of a disability or whether it be because of exclusionary discipline practices, or a combination of both, that those students tend to, because of the missed instructional time, have poor educational outcomes. What we mean by that is those students are more likely to drop out of high school. Those students are more likely to have to repeat a grade, and those students generally have lower grade point averages and test scores in comparison to students who have not been subjected to exclusionary discipline. And then the next point about juvenile system involvement and then criminal system involvement is the school to prison pipeline, right? What is not commonly known is that most children who become juvenile system involved originally started receiving suspensions and expulsions. And so I think it goes back to the prior point that is raised here, which is when these students are suspended and expelled, and they're at home with no supervision, that they tend to engage in criminal conduct or drug use, which leads to them becoming juvenile system involved. Another aspect of this direct school to prison pipeline is that oftentimes students are placed in juvenile system after having been engaged in altercations at school, or having been sent to an alternative education setting and then removed from that. It's like school, then alternative education settings, and then the next stop is juvenile system involvement. So that's what we mean when we say the school to prison pipeline, is that a lot of the offenses that lead to children becoming juvenile system involved occur in school. Chronic unemployment and underemployment as a direct result of, quite frankly, being undereducated, because students who are sent home are not able to participate in the general education setting and lose significant instructional time. Strained peer relationships due to the interruption of that peer relationship once a child is placed out of school, and negative self-perception and emotional conditions, including anxiety and depression. Students who are routinely subjected to exclusionary discipline practices or who are expelled tend to have negative views about themselves, which leads to issues that rise during adolescence, including anxiety and depression. Now, in terms of the adverse outcomes for schools, it was interesting that the Texas Appleseed conducted a study in which they surveyed school districts in Texas, the largest school districts in Texas, and they tracked the amount of exclusionary discipline practices that they engaged in, and found that that each school district, or collectively, lost $11.3 million from those students being placed out of school and not being present and accounted for. And then so for school districts, there are consequences to over-relying on exclusionary discipline practices that can result in the loss of funding due to student absences. Who is most likely to be subjected to exclusionary discipline practices? Children of color, due to implicit bias. Black boys are viewed as older and therefore less innocent than any other group of children. Tamir Rice comes to mind. I will say anecdotally, and I'll talk a little bit at the end about why this work is personally important to me, but anecdotally, when I was 11 years old, I was 5'6". I'm a very tall person now, I'm 6'4". And I had a deep voice when I was a child. And so there were multiple occasions in which I would have an encounter growing up in Mississippi with a police officer asking me if I was in the right neighborhood, or in school with a teacher who didn't know me and who automatically assumed that I was older than what I was. And so that's just an anecdotal example of Black boys being viewed as older and therefore less innocent than any other group. Increasingly Black girls, and that is because of the use of exclusionary discipline practices for nonviolent offenses, including uniform infractions, discriminatory hair policies in schools. You'll have young Black girls the National Center for Youth Law, or the National Center for Women's Law, did a report called Girl Interrupted a couple of years ago, and they tracked girls throughout the country, I believe, who were Black girls and who shared their stories of having been suspended repeatedly or sent to alternative schools because of the way that they wore their hair in public school settings, or because of, again, nonviolent offenses such as uniform infractions, school uniform infractions. And so Black girls are increasingly being subjected to exclusionary discipline, Latino youth. And this all happens as early as preschool age. The congressional, there's a think tank, a bipartisan think tank, that examines exclusionary discipline during any administration. And in 2018, this group found that again, what we already knew, which was that the exclusionary discipline practices, these suspensions that disproportionately impact children of color, begin as early as the preschool setting, where children receive notes from school teachers to their parents stating that the child needs to stay home for a couple of days due to having committed some behavioral infraction. And this is all, of course, due to implicit bias, the way that children of color, namely Black children, are perceived. And this implicit bias is not just born on white educators, it's born on all educators. And so the second group that is more likely to be subjected to exclusionary discipline is children with disabilities, namely children with non-apparent disabilities, such as autism and emotional conditions, including anxiety, depression, and post-traumatic stress disorder. There is very little work done on the preventative end and working with children with non-apparent disabilities when something happens that triggers their disability and it manifests in the form of a behavioral infraction. That work is not at all researched and tapped into as much as it should be. And more disturbingly, it's not implemented in schools as much as it should be. And so we'll talk a little bit more about the impact of exclusionary discipline on children with disabilities who suffer from academic disabilities, at least. Those students are already languishing in school. And so to have them removed from the school setting not only exacerbates their learning disability, but it also leads to them becoming juvenile system involved. 71% of juvenile system involved youth in this country have a diagnosable disability. And the reasoning for that, at least what research has indicated, is that when children have a disability, they're already at a disadvantage in the school setting. And when they're not provided with proper special education and related services, they further academically languish. And then once a child academically languishes, those behavioral issues start to manifest and come into play. And so think of it as, children who are existing in a world that is misunderstanding them and not providing them with the proper resources. And so their response is to act out. And then they are penalized for acting out based on the conditions that they've inherited. And there are other groups who are more likely to be subjected to exclusionary discipline for whom the data is limited. Children of incarcerated parents. That data set is limited because, quite frankly, those children are oftentimes too embarrassed to disclose that they have a parent who is incarcerated. Same thing for homeless youth. Same thing for LGBTQ youth. The data on LGBTQ youth and discipline practices is very limited because many LGBTQ youth are not in a safe environment to where they can disclose that they are of LGBTQ status. children in foster care, children with significant adverse childhood experiences, and youth from low-income families, all are more likely to be subjected to exclusionary discipline than groups who do not have those factors. And I think importantly, for us, we have to note the intersectionality of this work, right? And so when we talk about, for example, children with significant ACEs, well, Black and brown children are more likely to encounter adverse childhood experiences than white children, right? And so you can see the overlap in these categories. Even for children with disabilities, the use of exclusionary discipline practices is even more pervasive when the child has a disability and is also a child of color. And so when we think about, for example, the juvenile system, most of the juvenile system, at least in Louisiana, I will say, are Black youth, and they also have a disability. So there's definitely overlap in these factors when it comes to who is more likely to be subjected to exclusionary discipline practices. And so during the pandemic, school districts were presented with the opportunity to be innovative, to test modes of instruction that previously were underutilized or not relied upon as much, to rethink what community and parent engagement looks like in this virtual school era, to think about different ways to deliver services like English language learner services or gifted services or special education, Section 504 services, able to think about different ways to present these services and provide these services to children. And in large part, school districts did the absolute best that they could and provided those innovative measures. The one category where school districts nationally did more of the same was on school climate and culture. And by that, I mean discipline. So before the pandemic, I just laid out all of this research. School districts were relying on exclusionary discipline, despite the fact that there's no evidence that those practices work. Children of color and children with disabilities were primarily targeted or subjected to exclusionary discipline. And that is the same thing that happened during the pandemic. A Colorado student was suspended for 5 days after showing a toy gun while taking an online class. That was a Black child. A teacher saw a BB gun in a 9-year-old room's during online class. He faced expulsion. That was a Black child. 2 more Jefferson Parish students suspended for handling knives, swords during virtual lessons. Those were children of color. A teenager didn't do her work, so a judge sent her to juvenile detention. That was a Black child. And I had the opportunity to represent these 2 students, in what I called virtual school to prison pipeline proceedings. So even during the virtual school era, when it came to discipline, Black students, Latino students, and children with disabilities were more likely to be subjected to virtual school discipline than white students, than non-disabled white students, right? Same thing, same outcome as before the pandemic, after the pandemic. Now, virtual school suspensions and expulsions were in the literal sense, where a school would send a parent a notice that their child had been suspended or expelled, but it also looked in the form of blocking a child for a certain time period from accessing virtual classes. And so in one case, I examined a little girl, a Black girl, was her password had been blocked or changed by the school system so that she couldn't log into class as a way for her to serve a one-day suspension. Now, Jefferson Parish is in Louisiana. It is a school district that has previously faced complaints from the Office of Civil Rights, or filed by the Office of Civil Rights, the U.S. Department of Education, for over-relying on exclusionary discipline, namely school-based arrests against Black students. And there were 4 cases of virtual school suspension and expulsion that garnered national attention and really highlighted this virtual school to prison pipeline work. And so there are 2 students who are unnamed, and those are the students that I represented. Their families did not want to come public. And then there are 2 other students, one of which garnered national and international attention. And that first student is Kamari Harrison. So he is the 9-year-old Black child who was suspended in Jefferson Parish, Louisiana, and faced expulsion. And so what happened to Kamari was he was doing virtual instruction, just like we're doing right now. His teacher was providing a lesson, and his baby brother, walked into his room and tripped over his toy BB gun. And so to make sure that his brother didn't trip again, I'm going to show you what he did. He reached down and put the BB gun like such and placed it underneath his desk. And within that flash of seconds of him doing so, his teacher accused him of brandishing a weapon on school grounds, because the school district defined virtual instruction, your home, as a classroom when you're engaging in virtual instruction. That was their policy, to view school grounds as your home as long as you're engaged in virtual instruction. And so since he flashed a BB gun as such, he violated the school district's weapons on campus policy, and he was recommended for expulsion, and he served a 6-day suspension. That's Kamari. The second student is a white student named Tommy White, and he was actually the absolute last student to be disciplined out of the 4. Tommy White was 11 years old and in Jefferson Parish, Louisiana, attending public schools, and he was engaging in virtual instruction, and he mentioned to his classmates, he had a toy BB gun sitting on his desk, and he mentioned to his classmates, look what I have, look what I have. And his teacher saw that he waved the BB gun on camera. She noted that he did not do so in a threatening manner, and that he didn't, make any threats to anyone, but that he was showing it off to his classmates. But because of what happened to Kamari Harrison, the school district made the recommendation for suspension and expulsion. However, Tommy's suspension was only for 3 days. Now, the Kamari's was 6 days, and the other 2 students that I'm going to talk about, theirs was 6 days. Tommy was the only white student in the batch. So out of the 4 students of color, the white student incurred the least harshest punishment, right? And so this goes back to the data about who is more likely to be subjected to exclusionary discipline practices. Children of color, children with disabilities. But even when white students are subjected to exclusionary discipline practices, the data is very clear that they encounter them, suspensions at least, they have shorter suspensions than Black and brown students, right? And so Tommy's case is an example of that. Now, the two students that I represented, one of them is a ninth grader at Thomas Jefferson High School. He is Saudi. His family's from Saudi Arabia. And he had a disability. And the school did not have a, they had documentation of it. And specifically what he had was he had a medical disability. And one of the manifestations of his medical disability was that he would zone out and, quite frankly, get antsy, right? And the school had notice of this. And one day during virtual school instruction, my client checked out. And so the way that I am twiddling this pen right now, my client's adult older brother had a set of sporting knives, these butterfly knives, on the kitchen table. And so my client picked up the object nearest to him and started twiddling it. The teacher didn't even notice it, but the students did. And so one of the students pressed record on the virtual school instruction, sent the video of my client twiddling the butterfly knives for albeit 10 seconds and making no threats, sent it to his mother, who then sent the video to the school district, who then notified my client's mother that he would be suspended for 6 days and faced expulsion. And so I had to come in and represent my client in the expulsion proceedings. And I'll get into, the legal arguments that I raised once I talk about the fourth and final student who I also represented. Now, the fourth and final student was a student with a hearing disability. He was on an IEP, and he's a Latin student, he's a Latino boy. And he, as part of therapy for his learning disability, had been taking classes, martial arts classes, and learned how to use the katana, this sword, as a part of his martial arts classes. And he had been highlighted for his work as a 6-year-old and as a child. His family primarily speaks Spanish. And so he also is in ELL because English is a second language for him. And so between the language barrier, between his disability, and between simply wanting to fit in like all kids, during virtual school, he started a new class and he wanted to show his friends his katana sword. And so he showed them. He said, something to the effect of, guys, look what I have. And the students reacted to it. The teacher noticed the students reacting to it. And so she asked him what happened. And the student said he waved a katana. So the teacher never saw it. Said he waved the katana in class. And so she had him suspended for 6 days and recommended for expulsion. So my two clients were children of color and children with disabilities, right? So anecdotally, here we are, children of color and children with disabilities being subjected to exclusionary discipline practices. And so their parents both found me at the 11th hour, and I mean it in the literal sense of the word. The student who flashed the katana on his screen, I got a call from his mother's interpreter and advocate, who I knew personally, who I happened to know personally, hours before his expulsion hearing, hours before. And then the student who used his brother's kitchen knives or sporting knives during class, I got in contact with that family the day before. And so I have represented children before in expulsion hearings and in due process proceedings with regards to suspensions and with disciplinary proceedings for students with disabilities, but I never represented a child in a virtual school suspension or virtual school expulsion. And so I had to develop these novel legal arguments to advocate for my clients. And so the first argument that came to mind was that this was a right to privacy violation. Children have a reasonable expectation of privacy in their homes. All people have a reasonable expectation of privacy in their homes. They have the highest level of privacy in their homes. And that's, basic Fourth Amendment law. That's basic constitutional law. And my argument was that the school district's extension of its policy, its no weapons policy, from being on campus to someone's home merely by participating in virtual school instruction, constituted a right to privacy. And that argument was extremely unique in the sense that it garnered support from a cast of characters that I can promise you will never be on the same page again. And one of them was the ACLU, the other was the NRA, and then the third group was the third person was Louisiana's extremely conservative Attorney General Jeff Landry. So you had a civil rights and liberties organization, a gun lobbying group, and a state AG all issue statements in support of these cases against the invasion of privacy by school districts, right? Substantive due process violation I raised is that the parents really didn't have an understanding of the school's policy and that they would be impacted by it. So what I mean by that is the policy simply read that if you bring weapons to campus, that you would be suspended and even expelled. That was the school's policy. The policy in Jefferson Parish was never updated to discuss what virtual school campus grounds included. That was something that was done in practice, but it wasn't included in the policy. And so my argument was that the parents had no meaningful notice that they were violating the policy because the way it read, it only applied to on-campus events and not virtual school, right? And similarly, there were a host of procedural due process violations that came up. Because this was a virtual school expulsion, the parents that I worked with they didn't receive timely notice. They did not receive, some of them hadn't received the actual reports that were developed by the district, that were created by the district in response to the incident. The parent who spoke who spoke Spanish, she received all her documentation in English. And so that was a due process violation because she didn't have adequate notice, and therefore didn't have meaningful opportunity to respond to the accusations. And then there was these First Amendment violations that also brought those groups that I just mentioned back to the table. My argument was that the policy was vague in violation of the free speech doctrine. And so I presented a scenario during the hearing before the hearing officer of what happens when you have children who may be doing virtual instruction in the kitchen or in their parents' bedroom, and there's a poster in the back of something that maybe isn't appropriate for school grounds, right? Like I think the example I used is a poster of Tony Montana holding a gun, like a movie character, right? They're allowed to have those in their home. They have every right to have those in their home. But what happens in the virtual school era when that image is caught on camera? Do you say that they have brought obscene materials on campus, right? Like, where do you draw the line? I think was the chief argument that I raised. And so I raised the First Amendment challenge again on the grounds of vagueness, but also on the overbreadth doctrine, which saying that this policy was far overreaching more overreaching than what it intended to be, in terms of infringing upon students' and parents' rights to free speech. And then the other arguments that I raised is that in the process of disciplining these students, there were a violation of federal educational civil rights statutes. The student that I mentioned who was hearing impaired during his 6 days of suspension received absolutely no special education services during that time. And so he was sitting out for this offense and not receiving any services. So he was academically languishing. And then also, because his mother did not receive materials in Spanish, I alleged or I asserted that the school district had violated the Equal Education Opportunities Act, the EEOA, and Title VI of the Civil Rights Act of 1964, which requires for English language learners, for children as well as their parents, that they receive documentation from school in English as well as in the language that they primarily speak. That mother had, she actually had her oldest daughter, who was an adult, attend the hearing because the oldest daughter could speak English, and she served as a translator and an interpreter for her mother. But prior to that, she had no means by herself of understanding what happened to her son. She had to send the suspension and expulsion notice to her daughter, who then submitted it to me. And so I think the moral of the takeaway is, at least, that in this era of virtual school, discipline looks more of the same than what it did prior to the pandemic, and that the same civil rights violations that occur against particular students happened during virtual school, except the right to privacy and First Amendment violations were very novel and very specific to the virtual school instruction format. And so when I work with school districts, I advise them to minimize the use of exclusionary discipline practices, at least when I worked with them during the pandemic, as much as possible, and moving forward to do so as much as possible. The outcome of my cases were that the expulsions were overturned, so the children were able to stay in school. They had already served their suspensions. Tommy Brown and Kamari Harrison ended up filing litigation in federal court. They recently settled with the district. And as part of their settlement, all students who were subjected to exclusionary discipline in Jefferson Parish during the virtual school era, including my clients, had their suspensions removed from their disciplinary record. And so it ultimately ended up being a victory for my clients, as well as for Kamari Harrison and Tommy Brown. Another interesting component that came out of this scenario, particularly with Kamari Harrison, is that Louisiana passed the first virtual school discipline statute, the Kamari Harrison Act, which provided a host of constitutional protections that address the right to privacy issues and due process protections for any parent whose child is subjected to exclusionary discipline during the virtual school era. And so my recommendations for school districts, and this was, again, whether we are in the pandemic or beyond, is to refrain from using exclusionary discipline practices, particularly for nonviolent offenses. They don't work. They don't work. The data is very clear. Not only do they not work, but they cause more harm. School districts are encouraged to use their ESSER funds to increase the presence of school counselors and social workers to support students, to provide behavioral interventions, targeted behavioral interventions. The ACLU did a report years ago about comps and no counselors, and it basically talked about, school districts throughout the country over-reliance on SROs and not enough on school counselors. Having behavioral support teams use data to identify the disproportionate use of exclusionary discipline practices by certain groups and developing targeted interventions to address those that disproportionate use. The research is very clear that peer-led conflict resolution models conflict diversion programs, and social emotional opportunities all curb exclusionary discipline. And specifically, Project REACT, which is an equity-focused PBIS approach that I encourage all school districts to look into, has been shown statistically to reduce disparities in exclusionary discipline, particularly when the disparities are race-based. And so please look into Project REACT. Last note before I open the floor up for questions and commentary, there is ongoing dialogue about the relationship between school discipline and school safety. Obviously, with what happened in Uvalde being fresh on our minds and hearts, school shootings have increased the presence of SROs in school districts. However, the research doesn't establish that, just like exclusionary discipline practices, SROs don't make schools safer. At least that's what the research shows. But what we do have from the research is the presence of SROs results in increased rates of children, namely Black and Latino students, becoming juvenile system involved for nonviolent offenses. And that is because SROs have been used as school disciplinarians. And so what I advise school districts is, to the extent that SROs are to be placed on campus, they should never be used as disciplinarians. One, because that's not what they are supposed to do. But secondly, SROs don't have the training and understanding of working with children. And I've had a couple of cases where we've had a child with autism maybe responding to a something that has resulted in maybe a sensory overload to them, and they may start yelling and acting out. And we've even had instances here in Louisiana where SROs have restrained students, children with autism, handcuff them and try to sequester their behavior, is what they would say, and then charge them with assaulting a police officer whenever they responded, right? And so SROs have no business enforcing a school's code of conduct under any circumstances, to the extent that they should be involved in schools. I will open the floor for questions and leave it here with my James Baldwin quote.
Thank you so much, Victor. So we will go ahead and move over to audience Q&A. So the first question is, how do we invoke racial equity in all of this work?
So I would refer you back to Project REACT. It incorporates PBIS, positive behavior interventions and supports, from a racial equity lens. The first way that Project REACT recommends that you do so is through intentional extensive data collection, where, as I mentioned, you have a behavioral support team at the school level, not just at the district level, but at the school level, documenting who is being suspended, who is being expelled, what is the duration of the suspensions. And if they notice that there is a group that is disproportionately being used or subjected to that, then they have to engage in these behavioral supports rather than resorting to suspensions. And so I would urge you all to look at Project REACT again, because it provides a very detailed tier level response to addressing exactly that.
Thank you. So for the next question, are there best practices or guidance available to teachers on students' use of virtual backgrounds and cameras during virtual instruction?
Yes. And so one of the recommendations I have is for school districts to enact a very generic template, somewhat like the one that you have, Tawny, in your background, with maybe the school district's logo and put an apple on it or something. But that way, children that school districts can't see what's going on in a child's home. I've made that recommendation, and that was one of the recommendations that was implemented in Jefferson Parish after their series of virtual school suspensions and recommendations for expulsions.
What discipline or behavioral management resources would you afford to educators who teach acting out children? Do you acknowledge the existence of children who need an effective method of curbing inappropriate behavior on the part of children?
Absolutely. So, as I mentioned, I was a former kindergarten teacher. I had a couple of students who were diagnosed with IED, intermittent explosive disorder. And so they were chair throwers, they were desk throwers, they were throwers, right? And so what I will say is I knew that even though we had these challenging behaviors in class, I would never send them to the principal's office. The way that I approached that situation is I actually did something against the better judgment of my principal at the time. And I shared the issue with my students. And so that's why I mentioned peer-led conflict resolution as one of the ways to curb exclusionary discipline. I didn't obviously go into details about their diagnoses, but one day when the 3 students were out, I mentioned to the class, when you see this student get upset or perform or start throwing objects, here's what we are going to do, right? We are all going to, one, not acknowledge the behavior. Secondly, you all are going to look at me to see how I respond. And thirdly, you are not going to say anything to that student, right? And so that actually ended up being very successful because once the students realized that they were not getting attention from their behaviors, they stopped or they used their words. Now, I know that's easier said than done for maybe the high school level or the middle school level when you have students, fighting and things like that. Again, I say, peer-led conflict resolution skills have been successfully implemented in school districts to address that piece. And it's all about prevention, right? And so we had a model in middle school and it was called peer leaders, where it was maybe 6 or 7 of us in our 6th grade class who all maybe knew the entire 6th and 7th grade group. And so whenever there were issues that not only would come to a head, but if we knew they were coming to a head, we would actually alert the school counselor to say, this child and that child have conflict. I saw them arguing yesterday, and so I'm just putting you on notice. And we were able to do so in a safe manner to where those children would not be penalized, and that we could work with the school to troubleshoot the situation. We even had peer-led mediations. All of these things are effective at least preventing the behaviors, right? And so to your point about what happens when the behaviors actually happen, quite frankly, there are times when students have to be removed from the classroom setting. That's why I always said, view exclusionary discipline as an absolute last resort. And I think, for me at least, the only time when that becomes an issue is when children become violent towards their peers or towards an educator. At that point, it is necessary to remove the child from the educational setting. It's necessary, and I totally understand that. But I do encourage school districts to engage in methods, preventative methods on the front end to address that.
Thank you. So you make this distinction between behavioral management and support. How can lessons learned from the pandemic translate into in-school practices?
I would hope that the biggest lesson learned from the pandemic is that exclusionary discipline, with the exception that I just provided, should not be used, particularly for nonviolent offenses. I think if you have the same disparities in discipline arise in virtual school as they did in a regular school setting, I would hope that school districts would view that as a sign that what is being implemented is not working. And so my hope is that school districts learn from the pandemic that exclusionary discipline practices, when it comes to nonviolent offenses, should not be used.
Okay, and then last question we have. So you've shared a lot from the students' rights perspective, but do you have any last thoughts or insight from the teacher or staff perspective?
Yes, I think that one, it is incredibly challenging being an educator during the pandemic. I think that's probably the ultimate understatement. I think that when it comes to, again, a teacher's safety, a teacher has every right to prioritize their safety, which is again why, I mentioned if a child ever becomes violent towards a school teacher, then that child does need to be removed from the general education setting. And I would also encourage, at least I am having this conversation with the state's education department, that we need to enact a more public policy to support teachers. So I just wrote a bill that mandates, and this is already in place in New York. In fact, I fashioned the bill after New York, but it mandates mental health education in K through 12 for children, right? And so I view that as a way, as a preventative model for children to be able to address their trauma, their stress, their anxiety, or any conflict that they have with other students, and equip them with the tools to do so in a manner that doesn't resort to violent behaviors. Well, I would submit that we need legislation that provides teachers with mental health resources for themselves. I think especially after the pandemic, school districts need to be more intentional in providing teachers with mental health supports to deal with the stresses of being an educator. I think that, as I mentioned, teachers have every right to protect themselves and their person. I think particularly school districts need to do better, or state education departments need to do better in implementing mental health supports for teachers during this time.
Thank you so much. So Victor, I'd like to thank you on behalf of the YJI and everyone in attendance today for taking the time to share this incredibly important information with us. Before I get to the closing announcements, do you have any last thoughts for us, Victor?
One last thought, which is, I mentioned earlier, I would talk about why this work is personal to me, and it is because I am a survivor of the school to prison pipeline. I was first suspended out of school in the 3rd grade for correcting my teacher on a Black history fact. And because I was a tall child with a deep voice and a very strong opinion, I was routinely placed in detention and suspended throughout my childhood. And so I look at myself as a fortunate survivor of the school to prison pipeline, and I'm very committed to eradicating exclusionary discipline when appropriate.
Thank you so much. So I have just a few things to put on everybody's radar. The next YJI Lunch and Learn webinar session will be held on Tuesday, August 2nd at 12 p.m. We will be hosting Dr. Chris Herring, Assistant Professor of Sociology at the University of California, Los Angeles. During this webinar, he will be discussing the punishment and policing of homeless transitional age youth, its impacts, and alternatives to criminalization. The link to register for this webinar should be dropped in the chat now. Also, immediately following this webinar, we'll be sending a survey to you all via email. If you have the time, please complete the survey, as it allows you to provide further feedback for us and questions. This information is also used to improve future webinar sessions. This survey should take no longer than 5 minutes, and we will also be putting the link to that survey in the chat now. Finally, if you have not already done so, feel free to connect with us on Facebook, Instagram, Twitter, and LinkedIn. The link to those accounts can be found on our website. And just a reminder that the views expressed here are those of the presenter and do not necessarily reflect the views of the New York State Youth Justice Institute. In closing, I would like to thank you all for being a part of this session of the YJI Lunch and Learn series. We hope that you've gained something from this webinar and that you continue to think about what Victor has presented today. We look forward to seeing you at future webinar sessions.